They should be up within a couple of days. So with that, Lisa is the Chief of Case Issuance and Extraditions Division in the District Attorney's Office in San Diego County. And what I think makes her special from my perspective is her absolute commitment to evidence-based practice, and particularly also her knowledge of AB 109. I think she's considered the state's, the expert in the state who knows more about AB 109 than anyone in terms of the law. So she's going to be talking today then about the challenges with the practical application of AB 109 legislation. As we all know, when you develop the legislation, you do your best to get it right, and we know there's probably tweaks that will happen. And our concern would be that we really consider all of the different policy issues before we start tweaking it too much. So I think what she'll do is try to point out where some of those areas are. And we are so pleased to have you, Lisa. Thanks so much. And we will kick it over to you.
Great. Thanks for having me. It's a little awkward to speak directly to my computer. I can't see if you're laughing at my jokes or if you're groaning at them. I'm going to try to kind of go through all the slides and hopefully have some time left at the end. What I really wanted to do was focus on where the law is kind of conflicting with what we're dealing with every day, what the intent of the law was versus what is actually happening. So I'm calling it kind of the day-to-day, boots-on-the-ground overview of AB 109 and where we're at today and where maybe we can look to go in the future. So I'm going to jump right into it, hopefully. There we go. So some of the things that we're facing in AB 109, there's legal questions about who actually falls under which category, who's supervised by whom, under what circumstances, when can it change, who can actually get a local prison sentence. So I'll start off with some of the legal questions. Then I'm going to talk about some of the stumbling blocks that I think we're seeing kind of statewide for implementation and really using evidence-based practices. Talk a little bit about some of the internal inconsistencies within the law as well as within practice, and maybe even some of the inconsistencies in other laws that have been enacted since AB 109. I want to hit on the capacity issues because I think that really plays a fundamental role in whether we actually are able to do evidence-based practices and where we might need to look in order to accomplish some of our goals, and the changing populations both in the community, under supervision, as well as in custody. So let's jump into it. You know, AB 109 had about 12 pieces of legislation between the time it was written and the time that it was actually enacted. And there's been some big changes even after October 1st, 2011, when we first start using AB 109. We had SB 1023 and 1020. There's been about 30 bills that were put forth last year. I've seen about 30 or 35 this year. We still are going to have budget trailer language. So there is a lot of law relating to AB 109 and all sorts of different aspects of it. It really created a permanent shift of offenders from the state to the county. And I know a lot of counties were initially saying, well, it's a pilot project, or we're going to see how this program works out. And it's not a program, it's not a project, it is the law, and it's the way that we do business now, and the way that we will continue to do business for the foreseeable future. It really does change the nature of our criminal justice system and moves it from a state level down to the counties. We really did have limited time to prepare for AB 109. The first bills came out in late March of 2011 and were signed into law April 4th. We had until October 1st to get everything in place. And I think that a lot of counties, and I know in my county, we really focused on the immediate issues, the post-release community supervision. You know, we knew parole wasn't going to happen until next month now, which seemed so far away back in 2011 and now is less than a month away. Mandatory supervision, we knew that we'd get mandatory supervision offenders, but you know, it was really not a focal point initially because we had to deal with the immediate problem of post-release community supervision offenders coming to us, the immediate problem of offenders being housed in our county jail. So all these things working together, it basically boils down to this. Public safety realignment, it's complicated. It's really complicated, and even though we've been doing this for over 18 months, people still don't necessarily understand what they have. And I think in a lot of cases, people have kind of thought, well, I don't need to understand it. It'll just work out. And it's a difficult thing to come to terms with, and it's difficult to understand all the nuances. I want to start off by really describing the three types of offenders that we now have housed or supervised locally. We have the 1170H defendants, and you're going to see that I refer to the people who can be sentenced to serve a term in local prison as 1170H defendants. I don't like to call them non-non-nons, and I will explain to you later on why. But when I say 1170H defendants, I'm referring to the full and the split sentences. The defendants that can no longer go to state prison, they are sentenced to serve their executed prison term in our county jail. If they get a split sentence, they're under mandatory supervision, and they're supervised by probation. One thing I'd really like to point out is that this is a prison sentence. It is not probation. Somebody who's given an 1170H sentence has been deemed unsuitable or ineligible for probation. So it is just like a state prison sentence. It's just where it's being served. It's facility only, and then of course you have that option of a split sentence. The next new group is post-release community supervision. That's the PRCSs. Those are the offenders who go to state prison, and upon completion of their state prison sentence, they, instead of being released on parole, are released to the probation department to be supervised by probation. All of their revocations are served in county jail. So you can see we've got the 1170H defendants, we have the post-release community supervision offenders that are now taking up space in our county jail that didn't used to be there. And it's starting to change the nature of our jail populations. The next thing we have are our parolees. As I mentioned, starting next month, we're going to be handling the parole revocations, the warrants, and the modifications in our county court system, meaning that the DAs are involved, the sheriff's going to be more involved, the public defender, and of course the court now will have a role in handling the revocation process as well as the warrants and modifications for parolees. But already, and since October of 2011, all parolees, with a very narrow exception of the lifers and the SVPs, were serving their revocations in county jail, and they will continue to do so. So again, that's building up on our county jail population and changing how the county jail operates, who's classified there, and what's going on within the jail. So let's start off by looking at some of the legal issues about who qualifies for local prison and what some of the problems have been. Clearly, 1170H says that a felony punishable pursuant to this section shall be punishable by a term in county jail. There are about 500 criminal statutes that were amended to require sentencing pursuant to 1170H. I think initially everybody expected that it was going to be limited to H1, the 16 months, 2 years, or 3 years imprisonment in county jail. And I've seen some bills that have been put forth where they would limit it to 3 years. And really, when we were talking about this initially, we thought 3 years, you can handle somebody in local custody for 3 years. You know, good time credit, that's about 1.5 years for max, and we have people awaiting trial for that long. So we thought that would be, you know, more accessible, I think is probably the best word. What was surprising was when the law came out, we found that there was an H2, and that said imprisonment in the county jail for the term described in the underlying offense. And as we have seen over the last 18 months, I think the longest term so far might be 43 years in Los Angeles. But the reason that we get those big terms is because of H2. You can take a crime like drug sales. That has a base term of 3, 4, or 5. You have some prior drug sales under 11370.2. Each one of those could be 3 years. Got 3 of those, that's 9 more years. You have a large quantity, that's 10 more years. You have some prison priors, 3 or 4 more years. You can see how these can start to add up to be 20, 30-year sentence. And that has definitely changed the jail system, and it's changed what we need to do as communities and what we need to do for the offender both in the community and in custody. Some of the issues, though, that have come up around the 1170H is that non is really a misnomer. A lot of times that we like to say, oh, the crime is nonviolent, non-serious, non-sex, therefore it must be a local prison sentence. But in reality, a crime can be nonviolent, non-serious, and it still may require that an executed term has to be served in state prison. So it's really incumbent upon everybody to look at the penal code section or at whatever the criminal statute is, either the crime itself or the sentencing statute, to see if the crime was amended to include sentencing pursuant to Penal Code Section 1170H. Otherwise, it's still state prison. And, you know, I was going around saying this for a long time, and I was very happy to see that the case People versus Golan came out this year, and that case specifically said if it doesn't say 1170H, then it's still a state prison crime. And I know we had a significant issue with the Department of Corrections initially because they were reading the law to be if a crime was nonviolent, non-serious, non-sex, then the offender had to serve their term in local prison. And they were sending back state prison eligible offenders to our county jail, and we had to really work out that issue. So it's important that you don't rely on any list out there that says these are all of the state prison crimes, because I have yet to see a really full, clear, complete list of all of the state prison crimes. You have to really look at the statute itself to see if it's state prison or local prison. Another issue is that, as I like to put it, there's no degrees of severity when we look at 1170H crimes. They are all treated the same way. And by that I mean sometimes we have inconsistencies with other laws. For instance, a drug offender, simple possession of drugs and armed with a gun can be charged with 11370.1. That is a state prison crime. You take that same offender and he possesses drugs for sale, 11378, and you throw in the allegation of a 12022C, and that now is a state prison crime. Oh, is anybody else getting that echo? What's interesting about that also is the 12022C, while it makes something or is still a local prison crime, if you have somebody who qualifies for a 3-strike sentence and they are armed with a firearm, 12022C, they still qualify for a 3-strike sentence. So it's inconsistent with the new law that just passed for the new Prop 36. Also, we can look at 1203.07A11. That's a crime, or that's an allegation that says because you've sold drugs in the past, you are not eligible for probation. Yet, you may be ineligible for probation, you can still be eligible for mandatory supervision. And that's kind of inconsistent. The next thing is that it really paints with a broad brush. There's no distinguishing for 1170H sentences between somebody who is a drug user versus an honest-to-goodness drug dealer. They're treated in the same way. Somebody who commits a crime of opportunity, perhaps steals a car because they're high and they need to get some money, versus a criminal enterprise, an organization that steals cars to make a living. We treat them all the same under 1170H. Sentence enhancements have kind of changed as well, because if we are going to add additional time that the legislature provided for us, you cannot get the same kind of sentence in local prison that we used to get in state prison. And that may be a good thing, it may be a bad thing. It just means that those enhancements, the meaning behind them has changed. And finally, we're getting, because we paint with such a broad brush, because we have those sentence enhancements, because we have real criminal enterprise, we're getting those longer terms in county jail. And jails were not necessarily designed to handle these longer terms. And that is certainly creating some issues for the jails. Now, as you know, there are 3 exceptions to an 1170H sentence. We have the disqualifiers. If an offender has been convicted this time of a serious or violent offense or has a prior conviction for a serious or violent offense, they will serve their term in state prison. If an offender is a 290 registrant, a sex crimes registrant, they will have to serve their term in state prison. And then, of course, we have the 186.11 allegation, which I like to call the Bernie Madoff exception, if an offender commits a certain type of economic crime and on this particular offense, and that 186.11 is alleged and the enhancement is imposed on that crime only, that time they will have to serve their term in state prison. So those are the disqualifiers. If you have those kind of history or current conviction, then you will have to serve a term in state prison. Then we have the crimes that the legislature said, you know, we're going to pick these particular crimes out and say, yeah, we know they're nonviolent, we know they're non-serious, but they're bad enough, we think that this is a person that is better served for the community to be in state prison. That's like the 273.5 domestic violence, or a 245 an assault by means of force likely to cause great bodily injury. And then we have the default of Penal Code Section 18. If a crime says that it shall be punished as a felony, then Penal Code Section 18 tells us that those crimes shall be punished for 16(2) or 3 in state prison. And this stuff has been a little difficult for people to understand. There is certainly, there's been some counties that have tried to negotiate away 1170H. There have been some counties where where strikes have been stricken and they want the offender to serve in local prison. But the law is very clear that if somebody is supposed to go to state prison, then it's not something that we can really negotiate. It is very statute driven, and that's probably the key, that it is statute driven. If you fall under 1170H or if you have one of these disqualifiers, you must serve your term in state prison. Well, that leads to the next question then. Do we have to plead and prove those particular disqualifiers? And a case came out in January this year that said no, this is the People versus Griffiths case. We don't have to prove the disqualifiers. The legislature knows how to put a plead and prove requirement in there. They chose not to do so. It would have been nice, you know, if it had a little more specificity in the law to say whether or not there was pleading and proving, but now it has been read into the law that there is no plead and prove. However, what do we need to show? It appears from the Griffiths case that there should be some kind of notice to the offender, something that says, hey, you probably have a disqualifier here. You may want to get some information about that. And how much of that notice is going to be required for at least the defendant to have the opportunity to challenge a disqualifier. I think that is something that is certainly going to be litigated unless it gets clarified in the law. Juvenile strikes have been a really big question. If an offender has a strike prior from as a juvenile, does that mean that they go to state prison or local prison? And a case came out again, People versus Delgado, that says if the strike is imposed, if that juvenile strike is imposed, then the term will be served in state prison. And that was the Delgado case. And I think that was where we thought they would head because the strike law was passed long before AB 109. It is separate from it. And when somebody is sentenced pursuant to the strike law, they're sentenced under a different formula. They don't get to the 1170. But what remains to be seen is what if that strike is stricken? A juvenile strike, once it is stricken, is not a conviction, is an adjudication. And 1170H says a serious or violent prior conviction. So my belief, and again this will have to be litigated, is that the juvenile adjudication is not a conviction. So if it is stricken, it's no longer a conviction, it's an adjudication, and thus it's not a disqualifier, and the offender would serve their term in local prison, only for these juvenile strikes that are stricken. So that's something that will have to remain to be seen. I know the legislature has a couple of times tried to get juvenile adjudication as a disqualifier, and it has not gone through. And that's what makes me think that this is probably the reading that was intended. As you know, an 1170H crime, a sentenced to local prison, does operate as a prison prior. But there's been some problems with that and some concerns that have been raised by both the defense and the prosecution. For the prosecution, if an offender is out serving their mandatory supervision sentence and they commit a new crime while they're on mandatory supervision, there is no prison prior. They're still in the middle of their prison sentence, so it doesn't count as a prison prior. What you'll have to deal with is getting a new aggregate term. On the other side of that is that the washout to make that prison prior go away, if you go longer than 5 years without being in prison, it's as though your prison priors never happened and they can't be alleged to give that extra year in prison. That washout won't begin until the mandatory supervision period is complete. The other really big issue, and we're struggling with this statewide, is how do you prove priors from other counties? Not every county is recording the prison or the 1178 sentences in the same way. Not every jail is able to keep records of that and when offenders go in and out of custody, when an 1178 sentence is imposed. You don't even necessarily know whom to call in another county in order to prove that, or how to get a prison packet, because that's what we use. We use prison packets to prove priors, prison priors. So that's something that we're trying to work with statewide to come up with kind of a process, but it's very difficult when you have different levels of technology and data collection. So this is going to be an issue that will be fleshed out, I think, probably in about 2 to 3 years when we really start to see more of the offenders out that have been sentenced to local prison. One of the other issues that's really brewing right now is what if you had a sentence suspended prior to realignment and you now have that sentence imposed? What happens then? That's been a really big issue, and the first case that came out was Clitus, and it said, look, if that sentence was suspended prior to October 1st and you now fall under 1170H, then you will serve your term in local prison. The next case came out was Gibson and said, no, 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 that's state prison. Unfortunately, that was dicta, and that kind of takes me back to my first point about reading 1170H. In that case, the offender was convicted of Penal Code Section 12020. And that was a state prison crime. So the DA missed that that was a state prison crime, the defense attorney, the sentencing judge, the appellate defense attorney, the appellate prosecuting attorney, the AG, and the appellate judge all missed that that offender couldn't serve their term in local prison no matter when it had been suspended because it was a state prison crime. The 4th DCA recently came out with People versus Mora, and they read Gibson the same way and said it is indeed a state prison crime, and that crime was regular 1170H imposed prior to October 1st. But that's not the final answer, because People versus Scott came out just about 2 weeks ago, and that followed Clitus. So clearly this is an issue that unless it's solved at the legislative level, will have to go to the Supreme Court. Let's talk a little bit about mandatory supervision and where that fits into a prison sentence. As you know, H5 was added in prior to AB 109 becoming effective, and that gave the judge the discretion to order split sentences. And what we mean by that is that the court has the choice of ordering either the maximum term possible, all to be served in custody, or to split it between a period of jail and a period of mandatory supervision. Some of the issues that arise out of that is that the court can split the term of imprisonment in any way they want. Any amount of custody, any amount of supervision, as long as it totals up to whatever one of the sentencing terms would be, the low, middle, or upper, including, of course, any enhancements or allegations. But there's no rules of court. There's nothing to guide us on how you are supposed to split the sentence, when, or under what circumstances. While the offender is on mandatory supervision, they are supervised by the probation department. They're entitled to 1 day off the term of imprisonment for every day they're out of custody. In other words, an offender serving a virtual prison sentence. The idea behind this was to help transition offenders back into the community more successfully. The hope is that they're getting treatment, they're getting supervision, they are becoming productive members of our community. And every day is a successful day of their prison sentence. However, at the same time, it could be somebody who is committing new crimes, doing drugs, not working. Any of those things can also be a successful day of your prison sentence as long as no one's aware. The other thing, as I pointed out before, somebody could be statutorily ineligible for probation, but still eligible for a split sentence. So to split or not to split, we've seen wide variation statewide. We see wide variation within counties, from courtroom to courtroom, branch to branch, judge to judge, day to day. There's a lot of reasons for that. One is the length of sentence. You have to think about whether the sentence is long enough to get any meaningful time in custody for treatment services if you have them, as well as any meaningful time for supervision. So sometimes these shorter sentences, it makes more sense, at least from certainly the perspective of the defendants, and sometimes based on the county processes you have, the shorter ones just to be a straight sentence. Are there services? Courts are going to be more loath to split those sentences if there's not anything new for the offender to do while they're in the community. Sometimes defendants just don't want a split sentence. They would rather just do the straight term and have nobody supervising them, no search and seizure waiver, nobody involved in telling them what to do, when to do it, or how to do it. Sometimes everybody likes the finality of a sentence. It's a lot easier to resolve a case when you know what the term is going to be. Sometimes the DA, the defense attorney, even the court like to just get a term and settle the case for that. It's very scary to rely upon a later judgment of how to split a term. And so the finality of the sentence is playing, I think, a very large role in that. And of course, there's victim and public safety issues. Sometimes it's easier to tell a victim that somebody isn't getting a split, to explain to a victim what a split sentence is, or for a victim to see a defendant that they believe just got 3 years in prison for stealing their car, and the defendant's home next door to them a week later. These are things that play a big role in whether or not there's going to be a split sentence. And I think as we move further along and we become more comfortable with evidence-based practices, it is more likely that we will get a greater degree of split sentences. But that relies on changing the way we do business, because much of what we do business in the criminal justice system, at least at the court level, is about efficiencies and less about effectiveness. Is what we're doing working to reduce recidivism? And that's a real shift in how we do business. So when we talk about evidence-based practices and case disposition or sentencing, what we're looking at is, are we doing assessments? Who's doing the assessments? What kind of assessments? If they're doing assessments, who's getting the results? Are those being shared with the court, with the DA, with the defense attorney? At what point in the criminal justice system are those assessments coming? Are they before the case is disposed so that we know whether somebody's suitable for a split sentence? If we have the programs that would make a split sentence more desirable, make it better for the community? Or is it coming at sentencing after we've already negotiated a case? Has there been training on how to even understand evidence-based practices and understand assessments and what risk and needs are, as well as how to address those? I think that's a key issue that we need to look at in the future. And is there trust? Is there trust between all the parties in the criminal justice system that we can rely upon these assessments and rely upon our partner agencies to do the right thing and to use the programs that are available, again, to reduce recidivism? When we're thinking about a split sentences, we have to think about who, what's the risk level, the what kind of needs do they have, the where, do we have the treatment to address those needs, and really the why, what are the outcomes of the treatment that we have to address those needs to reduce that risk level. So things that we have to think about are risk and need scores, the desire to change. Are there any target services? Will the offender benefit from a time of transition? Does their criminal history tell us that this is an offender who really does need treatment versus somebody who is really a part of the criminal process, who's making their living doing crime? And I would submit that there's very few of those people that would not benefit from some time of transition. We have to think about restitution. Are we more likely to get restitution if an offender is released back to the community to mandatory supervision? And of course, how they've done in the past, and not just about how they've done, but how has probation or parole performed in order to try to address those criminogenic needs. Those are things that we have to look at. We can think about conditions by considering what's appropriate based on those risk and needs and what's available. Search and seizure is a big issue statewide because for many of our different types of populations, like parole, like post-release community supervision, there's an automatic search and seizure waiver. Not so for mandatory supervision. So that puts law enforcement a little bit of a disadvantage because they don't really know from county to county whether somebody has a search and seizure waiver. But other things we really have to think about are cognitive behavioral therapy, anti-theft classes, anger management, drug testing, and of course intermediate sanctions. Do you have something in your community that addresses both the positives as well as sanctions the negative behavior? and how quickly are those utilized, because that has a big effect on whether or not your programming and your supervision will be successful. Now, can mandatory supervision be transferred? This last summer, 1203.9 was amended so that mandatory supervision could be transferred from county to county. It cannot be transferred out of state or out of country. The same rules and regulations apply as it did for probation before, that a defendant can't be ordered to do mandatory supervision in another county. Probation actually has to contact the other county and see if they're willing to take them out. One of the problems with that is how do you transition them back into a different community? How does your community know that that offender is getting the services? And I think that's something that we'll have to look at as we go forward. Some practical tips is that we want to make sure the court's ordering the terms. We have to think about mandatory probation conditions, which should apply to mandatory supervision, like registration, DNA, and firearms. Multiple cases cause a lot of issues for us. Do the credits consume any time that would be on mandatory supervision if you're running cases parallel? Could a defendant start mandatory supervision on one case while still serving custody on another case? And sometimes concurrent sentences actually yield more time than consecutive if you're looking to try to maximize the amount of time that you can get on mandatory supervision. There's a big accounting nightmare with multiple cases too. So let's say your defendant's getting 5 years, 8 months on 2 cases, and the court wants 2 years and 8 months of it to be served on mandatory supervision. You have to think about how to break that apart so that while they're on mandatory supervision, they're being supervised under probably the least amount of cases in order to make it easier for the court as well as for probation should the offender ever be revoked. So in this case, you could do 8 months in custody on the subordinate case, then 2 more years and 4 months on the principal, and that would leave you with just that principal case while they're out on mandatory supervision. Another example would be if you have a 6-year sentence with 3 cases, and the court wants 4 years on mandatory supervision. 1 year can be applied to both of the subordinate cases, and then all 4 years could be left just on that principal case. But you can see how this can be really confusing, and keeping track of these can be very difficult. Some of the big challenges, of course, have been convincing people that 1170H is prison and not probation. When does mandatory supervision begin? Some counties have a date for an offender to appear for their custody. So are they on mandatory supervision before they start their custodial portion? And I would submit the way the law is written, probably not. Again, the search and seizure, it's not universal. That's going to be up to each county. How does law enforcement know if somebody's on mandatory supervision? What provisions have you put into your community to ensure that somebody knows? We have for parole and PRCS that it's put into leads, but in each of the individual counties and going up and down the state, it's not as clear if somebody's on mandatory supervision. What about notice? How does a DA find out if somebody's on mandatory supervision? Of course, the length of term is affected, and do defendants actually want mandatory supervision? When we're thinking about mandatory supervision, we have to ask ourselves, is it business as usual? Are we using evidence-based practices, the who, the what, the when, and the how? Is our court involved and engaged in mandatory supervision past just applying it? In our county, we did what we call the blueprint for success. We've created an accountability, a treatment, and a supervision model. So we have an assessment of the offender. We do mandatory program, treatment, and education while they're in custody. We have a multidisciplinary team approach. 30 days prior to release, they go back before the court to see what the offender's been doing in custody and to plan for the future, to find out where they're going to live and set up other hearings. And we try to have a seamless transition into the community services with programming and with a phased process. What about a revocation? If you have somebody on mandatory supervision, you need to know they're on mandatory supervision. How do you in your county know? How do you know what the conditions are? What is the plan for holding a mandatory supervision offender in custody if they get revoked? How do you know how much time is left on mandatory supervision? As you know, it makes a big difference if there's 5 years left versus 2 months, because every day they're out, you lose leverage for that carrot and the stick. When we're talking about a revocation, the court has the sole authority to terminate mandatory supervision. And by that I mean they can terminate them and return them to custody to serve the remainder of that previously imposed term. To figure out what to do, the court can either impose the full term or split it, but you got to know how much time is left. So we look at the total term minus the custody they've served, minus the 4019 credits, minus their mandatory supervision time. This becomes a game of days trying to actually figure the math out on these. Let's say you have a defendant who got 3 years with 1 year of it on mandatory supervision, and after 116 days they're revoked. That means you have a total term of 1,095. They did 365 days of custody with 364 4019 credits, 116 days of mandatory supervision. You have 250 days left to work with, whether it's a technical violation or you're wrapping it up with a new case. And when we talk about wrapping it up with a new case, some important things that people didn't quite recognize is that Penal Code Section 1170.1c only applies to state prison cases. If you're in state prison and you commit a new crime, that's going to be a mandatory full-strength consecutive. If you're in local prison and you're out on mandatory supervision and you commit a new crime, you can run the new crime concurrent or consecutive, but it won't be at full strength. It will be at either 1/3 or it'll be just concurrent. So that takes away the disincentive to commit crimes while on mandatory supervision. Sometimes a consecutive sentence will actually result in less time for the offender than a concurrent would. And I've done all kinds of math problems on this, and I thought about showing them to you, but I thought that might be a little too much information. But it's important to think about how we can fix this in the future so that it's clear that if you commit a new crime, then there should be a consequence for that, if that's what we want to do. I mean, you can always run it concurrent. We can always look at alternatives. But this does definitely change the nature of what an offender may or may not do while they're out in the community. And of course, as I mentioned before, they will be 1 prison term. Another problem that we've noticed is that for probation or parole, if you're on probation or you're on parole and you are convicted of a serious or violent felony, a new strike, an offender is mandatorily ineligible for probation. If a post-release community supervision offender is convicted of a new strike offense, they're eligible for probation, as is a mandatory supervision offender. I know that this is just an oversight, but it makes a tremendous difference. And we should not say that a parolee or a probationer should be treated differently and more seriously than a mandatory supervision or a post-release supervision offender. They're all post-conviction. They all should have the same response if they commit a new serious or violent offense. When we look at our post-release supervision offenders in the community, we see there's a shift in probation supervision. There's a shift in the type of offender they're supervising, and there's also a shift in the way that they are supervising. We're trying to move from law enforcement models to case management models, and that requires that there be availability of services and treatment, and that requires that money go towards it. It also requires that they look at these new type of offenders and figure out how to motivate them to want to take advantage of these new services and treatment. One of the impediments is to having people coming from parole to post-release. We're seeing that happen now with mentally disordered offenders being deactivated on mentally disordered as a disordered offender and transferred to post-release community supervision. When they pick up a new felony case, what's happening with that? Are we also revoking, or are we just going forward on the new case? And every county has to decide that on their own. What we're seeing, though, is an increase in the criminality and the severity of this population. As we move farther along in AB 109, we will have a population on post-release community supervision that is almost solely made up of offenders whose last committing offense to prison was non-serious and non-violent, but who has the criminal history, those serious, violent, and 290 offenders, that gets them back into state prison. You will not have 1170H defendants on post-release. All of them are going to eventually come out of state prison that were sent there prior to October 1st. You'll have a few of those crimes that are still the state prison eligible crime, like the 273.5, like the 245. But the majority of the offenders that are on post-release will have had a serious or violent criminal history. It's just that their last crime was nonviolent, non-serious, and they got a determinate sentence. So that's going to lead back to that shift in probation supervision. How do you move from a law enforcement model to a case management model with this more sophisticated and serious clientele? I wanted to touch on jail capacity. I entitled this portion, "That Old Jail Ain't What She Used to Be." Many probation officers, many parole agents have complained about the fact that you can no longer send a parolee, a post-release community supervision offender, back to prison, and that the sanction is limited to 180 days because we now are trying to use carrots without a stick. We're having a difficult time. There's a difference between a user and an addict. A user, you want to punish them and punish them quickly. I think that all evidence-based practices tell us that. It's about abstinence. It's about behavior. Whereas addicts, you sometimes want to use alternatives to try to address them in a slower fashion. Proximal, is more important, responding to the smaller issues as well as the incentives. But what was happening is we're treating them all the same, just like with the 1170H defendants. We are limited to the sanction. And so, for instance, with the GPS, whether they're using GPS as an alternative to custody or as a sex offender, there's no consequence for cutting off the GPS. It is a misdemeanor at best, and many counties are not booking misdemeanors, or they're not booking the parolees or post-release community supervision offenders. So there's not a real consequence for taking off your GPS. There's a less significant consequence for choosing not to take advantage of treatment or services because the custodial options are so limited. And that is really hamstringing our agents and our parole officers that are out in the community. We have offenders that are saying, look, I know the system, and there's not much you can do to me. And some of them even want the flash incarceration or want to be returned for a revocation because there's a whole new jail culture that's going on, and I'll hit on that in a moment. As you know, there's a big effect on the criminal justice system as a whole. Jail space is now a commodity, so we have to think about who do we actually want in jail? Who are the people that need to be taking up our jail space? We have more offenders under local supervision, and so that means communication between all of our agencies is a priority. That means we need to have more community involvement. We need to think about alternative sentencing. But that also results in a recycling of our low-level offenders when we're focusing all of our attention on the more high-risk populations. And of course, it's also changing our populations in custody. What we're seeing is that there's overcrowding. What we're seeing is that there's a lot of early release, and when a judge tells an offender you're going to get this amount of time, but they're really getting significantly less, that's not evidence-based. That's telling the offenders, don't take it seriously. We have an inability to book certain offenders. There's reduced consequences for all offenders across the board because jail space is limited. And we have more sophisticated inmates that are staying longer and more frequently, and that is changing the culture of the jails. And all of this is contrary to evidence-based practices. It makes it very difficult to apply incentives and sanctions when the consequences have to be driven differently. It's changing our jail. Before, offenders went to state prison for new convictions and parole revocations. I heard this likened to college. You know, when somebody goes off to college, they go and they deal with the college groups, and our felons used to go and deal with the prison groups. Now it's more like junior college, and when you go to junior college, you can stay engaged with your high school friends. You know where the high school parties are. You know what's going on in your community, and you stay involved in that. And that's what we're seeing in jail. Offenders are staying local. They're staying involved in the criminal enterprises with the criminal people that they were with before. So we're having an increase in ADSEG and PC housing. And we're having an increase in prison gangs, that we're actually building prison gangs in our local jail. And I hear stories about how offenders deliberately get violated in order to get back into custody to bring in information, to bring in drugs, to bring in other contraband. And of course, all these things, we have reduced consequences. The result is that working in jail has become much more dangerous. The result is that there's an increase in assaults both on jail personnel as well as on offenders. There's an increase in drug availability in custody. And that's affecting our evidence-based practices. That's affecting whether we can do what we're setting out to do. The costs to our sheriff are rising dramatically. We've got to deal with supervising different types of offenders. We have to deal with classifying offenders in a different way and trying to classify them to get them into the programs that we want to have available in jail. We're creating treatment and services in jail that didn't used to exist, and that's a good thing. but that's an expensive thing, and we have to figure out how to apply that. A big issue is time management, and I don't mean for the sheriff, I mean for the offenders themselves. If you have somebody in your county jail for 10 years, what do you do with all that time? Because unproductive time is dangerous time, and that's something that jails really have to consider that they didn't used to. The legal costs are also rising. All of the lawsuits that were visited upon the Department of Corrections are starting to be visited upon our sheriffs, and they're going to, when you have people with time and nothing else to do, those legal issues are going to increase and the costs are going to increase, and we're already seeing sheriff's departments being sued by inmates. Dental costs are rising and medical costs are through the roof. Before, most counties, you had an average stay of about 40 to 60 days. Now you have people staying for years, and you have to deal with the medical problems that arise out of that, even just the day-to-day medical issues. And so those costs are going up as well, and I'm not sure we ever are going to get enough money to be able to handle that. Finally, I think one of the biggest issues is outcome measures. Defining recidivism, and I put bubbles around this because it really is so nebulous. Every county is doing it different, and I know that CPOC has come up with a definition. I believe the sheriffs have come up with a definition, but they are more or less, I would say, they're engendered in a certain way to deal with particular issues that they're facing and not necessarily overall. And so we really have to be careful about how we define recidivism. How do we measure it? Does your county have the technology to measure it? And can we measure it across agencies so we know if an offender got an 1178 sentence, what happened to them in jail, and then what kind of services were provided them in the community, and were they successful so that we, using evidence-based practices, that we know it was successful, we had a good outcome, we want to put more money to that. The ones that weren't successful, how do we know they're not successful so we cease to put money towards that and we can put more money towards the ones that do work? So we've got to be able to share across the agencies. We also have to figure out how to compare it amongst our own counties, amongst the state, in comparison to what the Department of Corrections did before. There needs to be a decision about how we're going to compare this information so we know what is being successful. And then we have to evaluate. We have to evaluate what we've done, what we're doing, so that we can make good decisions. And that's really what evidence-based practice is about. It's about figuring out what's working and what's not, because we want to take the things that are working and we want to spend more money on those so that we are more successful, because the goal here is to reduce recidivism. The goal is not to build more jails. The goal is not to get more people under supervision. The goal is to reduce recidivism, because that's what's good for public safety. So I leave you with this, the challenge. How do we use evidence-based practices? We need to do more training. We need to figure out how to apply it in our courtrooms. And we need to have an acceptance of it from one agency to the next, from public defender to DAs, because and court, we've got to accept it. And we have to shift from the efficiency model to the effectiveness model. We have to figure out not how quickly can we get somebody through the criminal justice system, but what's most effective to reduce their recidivism. And that is a tremendous culture shift. We have to look at increased programming both in the custody and in the community, because if we're not treating the offenders while we have them in jail, we are going to produce offenders that are more likely to recidivate. And we have to bulk up what we have available in the community because we want to build upon what we've done in custody. We want to look at our parole, our mandatory supervision, our post-release community supervision, revocations. Are there other alternatives that we can use besides custody? And how do we get them into the available treatment and services and get them engaged in that process, again, to reduce recidivism? Finally, it comes down to creativity and accountability. We have to be creative with what we have and what we can get and with our money. We have to hold not just the offenders accountable so that they're less likely to recidivate, but our partner agencies. If we hold ourselves accountable, then we are more likely to be successful. I want to point out the best place I go to for updates. This has the most updated law It's the leginfo.legislature.cal.gov. It not only has all of our code sections, but you can find out updated information on bills. I look there probably 10 times a day just to make sure I've got the law right. And that's it for me. I actually managed to finish in a reasonable time, so we have some time for questions if anybody has any questions.
Thank you so much, Lisa. I am always amazed at how you can take such a complex subject, and I can get it. So if I can get it, probably most everybody else can. We do have one question right now. Is what's the best way to distinguish objectively the difference between a drug user and an addict, or between an opportunistic and an enterprise criminal?
That's a great question, and I would have to say there is no easy way to do it. You know, I don't know if anybody out there knows Doug Marlowe. He's probably the preeminent expert on evidence-based practices and its application. And he would tell you that you have to do assessments first and foremost. You need to figure out what kind of assessment is going to give you the, particularly for addicts, give you the difference between somebody who's just using because they like it or it makes crime better and an actual addict. So the assessments play a huge role in it, and finding the right assessment. I think the GAIN is one that he really recommends. There's, you know, so many out there. The next thing is being able to understand and interpret those assessments, and then using that criminal history, because if you look back at somebody's criminal history, you can often get a pretty clear picture of who your offender is. You know, somebody who's got 10 drug sales, but they're all for a small amount of drugs, that's somebody who's selling to get their next high, versus somebody who's selling large quantities of it, who typically is not a user. You know, it's things like that. It's using cognitive behavioral therapy, because many times cognitive behavioral therapy is going to help us retrain the way somebody thinks as opposed to just addressing their addiction. If you can't change the way somebody thinks, then they're going to go back to what they know. So it's really, you know, looking at the big picture of the individual and taking the time to really look at all the information that you have before making the decision, because so much of what we do in criminal justice is just gut reaction. I did dispo for about 5 years, and so many times I had that sense that, oh, I could just look at somebody and tell. And honestly, after having worked in reentry, you know, we're wrong more often than we're right. It's really about who the offender is, what can we do for them, and are they ready for it?
Great. Another question we have is, are the judges properly trained on the sentencing provisions that you covered?
I know that there has been a lot of training for the judges, but you know, this is a really complicated area of the law. It is probably the biggest fundamental change to our criminal justice system, and honestly, unless you're dealing with it every day and looking at it, it's hard to recollect every part of it. And so I think statewide there is certainly a concentrated effort to educate the judges, and I know the judges want to understand it. I think it's just hard to put into practice.
Question, Lisa. Given all of the issues that you've laid out today, if we put you on the spot and said what would be the top 2 or 3 legal refinements that you think are needed in the law, would you be able to isolate those for us?
Oh my. I think if I were to, I would have to really give that some thought. You know me, I'm not a off-the-cuff kind of person. I'd like to mold that question over. Some of the, I think probably the biggest issues, though, are really clarifying what the legislature intended in 1170H, and probably, you know, some people have talked about making it more universal, like how we would handle prison priors, making it more universal for the assessment process. The biggest issue to me on an implementation level would probably be the outcomes and being able to figure out how we can share that information and get some consistent data.
Oh, sorry. I take this on or offline after the seminar, but I would be interested in, if we were going to clarify the difference between a drug dealer and a drug user, what part of the penal code would we be looking at?
Well, I'm not sure that I'm not sure that there's anything in the penal code itself that helps us to distinguish that. You know, that,
Okay.
and you know, I didn't say this, but one of the truly fundamental issues with 1170H is one of the first ones that I talked about, which is painting everybody with a broad brush, that the way the law was written, we treat all 1170H defendants the same. They're all eligible for a split. You know, we don't have any way of distinguishing right now that there are certain people that aren't amenable to treatment or that really should have more serious consequences. And I'm not sure how we can fix that. But I'd love any suggestions.
Okay. So another question is, you discussed the impact on the jail environment. Do you have any information about how county probation departments are dealing with the increasingly dangerous population they're supervising?
I really don't. I know there's a lot of training that goes on.
Okay.
That's a question better left to the probation departments.
Right. Okay. So I think we are pretty close. We've only got just a couple minutes left, so I wanted to just let you know about a couple things that are coming up on our agenda for the partnership. We have a forum coming up on June the 21st that is going to be looking at split sentencing, which is clearly we've talked about today, and there's a lot to be discussed on that. And we have, I think, presenters from 9 different counties, 4 probation chiefs, 3 judges, and prosecutors and public defenders, and also and sheriffs and police. So, and we also have another question, so let me get this one in real quick here before we go on. I don't see how sheriffs can ever provide all the job training resources state prisons do.
You know, I would have to say, just looking at my own sheriff's department, I have been astounded and so impressed with what my sheriff has done and the way that he has grabbed a hold of this with both fists and is doing everything that he can to provide as many services to the offenders while they're under his custody. It's really remarkable, and I think that that's just a decision that has to be made by each county in how you split up your money and how the money's used. And it goes back to that trust thing. You have to be able to trust your other partners that they want to provide those services, because this really does cut across all of our agencies, and unless we're working together, we cannot succeed at this. My sheriff has even gone so far as to change the name of one of our facilities to the East Mesa Reentry Facility, so that we use that as a step down so he can provide the education, the vocation, the treatment. And they have a class schedule that looks like a college course schedule of all the different things that are available, putting the right offender into the right service. So I think it can be done. It's just a matter of shifting the focus to making it so.
I think we're seeing a lot of sheriffs do that. We've been hearing about a number of jails that are doing that. So one other last thing before I thank Lisa, I wanted to make sure everyone on the call is also aware that the partnership is doing a number of convenings around the state. Lisa addressed the issue of the medical costs in the jails, but we also have all sorts of costs in the communities around behavioral health where we can really have a decrease in recidivism as a result of expanding, because we'll have a bigger offender population eligible for Medi-Cal. So we're going to be doing at least 3 different convenings around the state on that. We're also helping Long County with jail overcrowding, and another on reviewing their AB 109 plan. So if there is something that your county in particular has some interest in, we can assist with that. So please just give me a call, and if you go to the website, you'll have my number and all that information, and in all my emails I send. So with that, I want to thank Lisa. You are absolutely incredible in your knowledge and your ability to explain this highly detailed information in such a very practical way for those of us in the field that are really doing kind of the day-to-day stuff. So I want to thank you again, and I want to make sure everyone knows that we will be sending you a survey, which we hope you'll complete, along with the link to the presentation. And so please do return those evaluations so that we can learn from every one of these that we do. So thanks again, Lisa, and to everyone for joining us. Have a great day.
Thank you.